Good day. Welcome to Learning Thursdays. I am Patty Corbett Ward, and I would like to welcome you to the November edition of Year in Ethics. It will be brought to you today by Mark Boss and Maria Passeri. I will introduce them to you in a minute. I just would like to, as always, do a little overview of Learning Thursdays. The educational series is offered to professionals in our field as a free learning opportunity to help improve the knowledge, the skills, and the attitude of folks who work in the field as you strive to improve the lives of individuals in prevention, treatment, and recovery. In part, we do this by bringing you presentations that are relevant and current as a way to help you master the competencies you need to do your clinical job appropriately and to the best of your ability. That being said, I would like to let you know today you'll be watching Year of Ethics, Confidentiality, and Communication. And as I noted earlier, your presenters today are Mark Boss, who is part of OASAS Council, and Maria Passeri, who is the director of the OASAS ATCs. Again, and as always, if you have questions about the presentation, anything Learning Thursdays related, please send your questions to the mailbox noted on the slide, and staff will get back to you as soon as possible. That all being said, I would like to, at this point, thank Maria and Mark for being here and turn it over to them. So enjoy the presentation. And folks, thank you for joining us today. We appreciate it.
Thank you.
Thank you.
Hello, everybody. Welcome again to Learning Thursdays Year in Ethics. Today we are doing confidentiality, and I'm very happy to have Mark Boss here with me to present this topic, as there have been a lot of changes with confidentiality, and our field has changed greatly in that we are now providing care that is documented through an electronic medical record, and we are working with different types of programs and insurers and dealing with individuals' private health information. And so today we're going to go over the goals of the presentation, and hopefully we will make some sense of this for you. And we are also always available for questions through either phone calls or email if you don't understand something that's been presented today. So let's get started with the goals of the presentation. First, we want to be able to gain a greater understanding of the federal laws of confidentiality, including 42 CFR Part 2 and HIPAA. We also want to become knowledgeable of the final rule, and this final rule was adopted in January of this year, 2017, and it became effective March 21st, 2017. We also want you to understand how to put together a proper format for release of information. We want you to be able to state the exceptions of the law. And we want you to become familiar with the process when there is a breach in confidentiality. As it is a reportable incident, it's considered a significant incident with the Justice Center. And we also want to understand the New York State laws, the OASAS patient rights, and credentialing regulations for confidentiality. We also finally want to be able to have you state the procedures for filing a violation of privacy. So with that, we'll get started with the presentation. And we're going to start with the historical perspective. And confidentiality for our field started around the 1970s. The federal government enacted 2 laws to guarantee strict confidentiality of information about persons receiving alcohol and drug prevention and treatment services. So one law focused on the alcohol abuse, and the other one focused on drug abuse, just as our agency was at that time, 2 separate agencies for alcohol and drug addiction. Also during that time, both laws were merged to provide a single set of federal regulations. So in 1986, there was an amendment to move the restrictions on programs' compliance with state laws when it had to do with mandating reporting of child abuse and neglect. And as you know, we can always protect confidentiality, but not when there's any kind of endangerment of a child. In 1992, Congress also consolidated the originally separate statutes into a single federal confidentiality law covering both alcohol and drug abuse records and information. Then we moved on to HIPAA, and that was the Health Insurance Portability and Accountability Act of 1996. So in 1996, HIPAA passed this act, or Congress passed this act, I apologize. In 2002, the Health and Human Services released final rules in governing the privacy of healthcare information. And those rules went into effect in April 2003. And so they included drug and alcohol treatment programs, health plans, healthcare clearinghouses, and specific security and electronic standards. So why all this privacy? Why are we bound by HIPAA as well as 42 CFR Part 2? It was really important for those individuals who had substance use disorders for them to feel comfortable about seeking treatment. And we even know today with the stigma and the concerns, most of the individuals that need treatment haven't accessed treatment. And so it's really important for us to ensure that confidentiality so people feel free to access treatment. Also, we're concerned that highly personal and stigmatizing informations could result in damaging consequence to the person themselves, their family members, and professional life. HighTech now, which is the Health Information Technology for Economic and Clinical Health Act, which is a very long acronym, really was passed in 2009. And really what the key provisions to this particular act was it provided even stronger patient rights, such as the right to receive an electronic copy of your personal health record. New information regarding minimum necessity. So what that means is really we should have what's a limited data set in terms of what individuals need to disclose about their personal health information. So we don't necessarily need to know everything. What is minimally necessary for us to conduct treatment. Also, these with the stronger patient rights came stronger enforcement and penalties. So covered entities are now subject to civil money penalties based on increasing levels of culpability as well as civil actions by the attorneys, the state attorney general. So I'm going to turn it over to you, Mark, and talking about the final rule, which is very confusing, I might add.
It's a little confusing because there have been a few adjustments. I'd like to say that basically Part 2 remains pretty much the way it always has been. There is now a nuance that's been put into play by SAMHSA with the final rule that just came out effectively in March. And that is the distinction between a treatment provider relationship and an entity who's receiving information that isn't a treating provider relationship. So under the new final rule, if it's a treating provider relationship that the individual has, the information can be disclosed pretty much like it's always has historically been disclosed, through a consent format with the organization identified. Let's see. So basically, the way we've always been doing things, if you've got one or more treatment provider that need to have the information disclosed from the program, multiple recipients can be indicated on a consent, and they all can have access to the information that is identified as being permitted to disclose. So, thank you. So what SAMHSA has done is try to delineate what constitutes a treatment provider relationship. And basically what SAMHSA is saying is that at any point, if a patient reaches out to a provider of services, or if the provider of services is in contact with the patient, there's any type of agreement for services to be rendered between the provider and the individual, that constitutes a treatment provider relationship. These are all services that are directly related to health or mental health care. They are distinguished from any kind of services that don't have to do with any type of health care. So relationships that require disclosure of confidential information about a patient, say with parole or law offices or accounting offices or any kind of service, information exchange service, any kind of exchange service, or I'm sorry, any kind of information service that doesn't have a direct bearing with treatment, providing of treatment to that individual. Under the new final rule, there's an additional requirement that not only the name of the organization that the disclosure will be made to will be identified on the consent, but the name of a specific individual in that organization to whom the information will be disclosed. So this is a bit of a nuance that is still being felt by felt and trying to be understood by the treatment provider community, because the question the question arises as to what we do when we identify a particular individual in an organization, but that individual moves on or for some reason is no longer active in the service that was being provided to the client. So SAMHSA is under the process of working out guidance that we're all looking forward to see how they answer that particular question. And our understanding is that guidance should be out in a month or two. So we'll have to see exactly how the subsequent disclosures to these non-treatment provider organizations and individuals are addressed. So one of the other forms of guidance that SAMHSA has provided in the final rule is they've clarified who or what constitutes a qualified service organization. In the past, it's been recognized that one treatment provider could not be a qualified service organization for another treatment provider. But services such as labs and pharmacies and law offices and accounting and billing, those were all considered to be acceptable qualified service organizations, and they still are. What SAMHSA's done here is they've sort of expanded the concept that beyond the fact that another treatment provider cannot have a QSOA that two treatment providers cannot have a QSOA between them. SAMHSA now also says that a program cannot have a QSOA with a medical provider, someone who's going to provide direct medical services for their clients. So that's a little bit different than a little bit more expansive. If there's going to be any kind of communication between a program and a medical provider, physician, related to the services to be rendered, it has to be done through the client's consent. So because SAMHSA wants to sort of open up a few definitions of who has the ability to further disclose information, they've also come up with this new term called a lawful holder. And a lawful holder, under the final rule, is any entity or individual who has received confidential protected information either through a patient consent, and they're holding that properly and lawfully, or they've received it through one of the other Part 2 exceptions. Once they're a lawful holder of the patient identifying information, they then they're bound by Part 2, which is a good clarification, and then they have to follow the same rules if there's going to be any kind of subsequent disclosure of that confidential protected information. And lawful holders include hospitals, emergency rooms, insurance companies, any entity that has done an audit or evaluation on a provider. So as we go through some clarification that came out of the final rule as to the consent format, under the section of to whom the confidential information can be disclosed to, a patient can now list the name of an individual, the name of an entity which has a treating provider relationship with the patient, the name of the entity which the patient does not have a treating provider relationship and which is a third-party payer, or the name of an entity which the patient does not have a treating provider relationship and which is not a third-party payer, such as a health information exchange. And if it's not a treating provider, then in addition to the name of the entity, the consent has to include the names of a specific individual or the names of the entity participants with which the patient has a treatment provider relationship, or a general designation of participants with which the patient has a treating provider relationship. So so there's just a little bit of nuance here. If it's not a treating provider relationship, then again you name the entity and a particular individual. If it is a treating provider relationship, you can name the general designation of the entity with which the client is willing to disclose the information. And you still have the ability to have multiple parties on a consent, both treatment provider and non-treatment provider, as long as the name of the individual and organization of the non-treatment providers to whom the information is going to be disclosed are indicated on that consent. And then from whom, there's a little bit of a change here as well. The rule allows disclosure to and among participants in an integrated care environment, such as a health information exchange. And of course, that's not new. That's always been the case. It will permit a disclosure from Part 2 program to the intermediary and then to another treatment provider. So that's a little different, but not that that couldn't have been affected under the old rule, but here it clarifies that that is a permissible exchange where the consent indicates that disclosure from the program to an intermediary with the recognition that that intermediary in turn will further redisclose to an identified party on the consent. The amount and type of disclosure, of course, it's always been known under Part 2 that that the minimum amount of information that is necessary to be disclosed for a particular purpose of the consent should be indicated. These days, of course, that's a little bit more difficult with some of the electronic exchange systems. So to try to tighten that up to the extent that's possible with the system, SAMHSA is now saying that there has to be some kind of qualification to the designation of what information is going to be disclosed. So what's acceptable is to say all of my substance use disclosure records. What's not acceptable is to say all of my records. obviously there the distinction is that the individual is intentionally identifying the fact that they recognize that all of their substance use disclosure records will be subject to disclosure under that consent. So under the established Part 2, essentially from its inception, there's always been a requirement under Part 2 that patients receive notice of their rights under the confidentiality law upon admission into a program. And SAMHSA under the final rule has expanded that to indicate that if disclosure is made via consent to a non-treatment provider entity, such as a health information exchange system, that the patient also be provided with the right to request and receive information from that exchange system as to who has accessed their information. So the intent is obviously to have some kind of control and restriction or some ability to audit who might be actually accessing their information when that entity is not or does not have a treatment provider relationship with the client.
Okay. So thank you, Mark. Now we're going to move towards some general rules in regards to both HIPAA and 42 CFR. So first of all, we have to understand that any patient identifying information is considered protected information. So, and we talk about that with the acronym PHI. This information that would directly or indirectly identify a person as a patient with a substance use disorder. It also includes information that will reveal a person's status as a current or former patient, such as the patient's identity, address, medical or treatment information, and all communications made by the patient to the program staff, whether it's in writing or another form. And so what we have to remember is even within the confines of our program, we have to be mindful of what we're saying when we're with the patient or when we're talking in a hallway or in earshot of other patients. HIPAA's protection is a little bit different. It's broader than the substance use information. It includes information, whether it's oral or recorded, that is created or received by the health care provider, health plan, public health authority, employer, school, life insurer, or health care clearinghouse, which is related to past, present, and future physical or mental health, including the payment for an individual's care. So another area that we are moving in our field is to telepractice, telehealth, and we also need to be mindful of the protected information about the patient in that format as well. So when we take a look at who are the protected individuals, protects patients who have applied for, participated in, or received an interview, counseling, or any other service from a substance use program. And if a person doesn't show up for an appointment that was arranged by a third-party person, that person is not a patient. And so both HIPAA and 42 CFR Part 2 protect former patients and deceased patients. And that sometimes often is a question that comes up because family members will contact programs after someone has deceased for information. So 42 CFR Part 2 defines disclosure as any communication of information about an identified patient or information that would identify someone as a patient, including verification of information that's already known by the person making the inquiry. So we may not disclose that a person is attending a program that is publicly identified as a place where substance use treatment is provided. So one question I want to ask you, Mark, and I want to go back to the situation with deceased patients, because due to the opiate epidemic, and we have many family members contacting us who have an individual who has passed away, and they're requiring information maybe for the life insurance policy, or that they may feel that they want to move ahead with some sort of lawsuit. Who is able to access that information at this point? Is there, if a family member had the consent during the program, is that still valid, or is there another way that the family member can get information?
Right. So the consent from the client themselves would no longer be valid, because the consent ceases upon the death of the individual.
Okay.
So under Part 2, it is permissible to disclose information. The question is whether the deceased had an estate, and a court has appointed a representative of the estate. If that's the case, then the representative of the estate can request the information with proof that they are, in fact, representative of the estate. They sign a consent as the executor or the administrator of the estate, and the information can be disclosed to them. Now, in a large number of cases, there is no administrator of the consent or of the estate. So Part 2 recognizes that in the event that there is no administrator of the estate, that a responsible family member, generally a parent or a sibling, can stand in the place of the deceased individual and request information. And in that case, that individual will sign a consent as that representative of the deceased, and then the program can rely on that to disclose information.
Okay, thank you very much.
Sure.
Thank you. Okay. In terms of providing administrative requirements, it's important that programs designate a privacy official. So that's an important piece of information that we want to make sure that you are aware of. So you need to go, if you're not aware of who that is in your agency, that's a question you need to ask. We also feel it's really important to train all members of the workforce on HIPAA's Title 42 CFR policies and procedures. And that's not only the clinical staff, but your office staff who might be providing information when there are requests for information that come from various community entities. Also, it's important to implement appropriate administrative, technical, and physical safeguards to protect the privacy of the patient information. Programs should assure that security of confidential information is stored and transported in both electronic and paper files. And also they need to have a clear process for making complaints. So there should be a policy and procedure on confidentiality, what happens when there is a breach of confidentiality, and how to make a report. And as I said before, confidentiality is a significant incident in the Justice Center. We also need to establish a system to track and document all disclosures of patient information and provide to patients an accounting of these disclosures upon request. And this is really important. So if a patient asks you, I need a list of all the people you have sent my information to, we have to provide that for them. We also need to put in procedures in place to limit the information to the minimum necessary, as I talked about before, to accomplish the intended purpose of the disclosure. And we need to document all privacy policies, procedures, and personnel designations. There are some exceptions to the rules, and there are 10 categories. So these are situations that are the exception to Title 42, Part 2. First one being a written consent. Clearly, we can give information when there's a written consent. Also, internal communications. So when there's internal communications amongst staff, the multidisciplinary team meetings that we participate in. And it's important to tell our patients that we do this and explain, because oftentimes they don't understand why other counselors may have information about them. But we also know in how we transact our treatment program, we have the multidisciplinary team meeting, we have the case conferences, we also have individual counselors and counselors who run groups. And so in order to share appropriately and provide comprehensive treatment to the individuals, all those individuals within the program need to be communicating. And I think sometimes our patients don't necessarily understand that, so it's important that we provide that information. There should be no patient identifying information posted in the facility. Oftentimes we see confidentiality breaches within admissions programs because they list the people who are coming in on a board with first and last names. So that's where sometimes full names can be a problem, or the sign-in sheet as someone comes into the program. Also with medical emergencies, that also does not need a consent. Court orders, crime at a program and against program personnel. And as we move on in this presentation, Mark is going to provide you some specific information about court orders and crimes committed at the program. Also within research, audit and evaluation, child abuse, and qualified service organizations, which we talked about earlier in this presentation. So, when we talk about the proper format for consent to release information, we need to satisfy both requirements, 42 CFR Part 2 and HIPAA. So, what we need is the name of the individual or the name of an entity, which is the treating provider relationship, which Mark talked about earlier, with the patient. It could be the name of an entity which the patient does not have a treating provider relationship and is a third-party payer. So we do need a release of information as we are communicating to insurers with regard to authorizations and concurrent reviews. Also, the name or entity of the patient who does not have a treating provider relationship and is not a third-party payer. So those are different people or participants, as Mark talked about, which could be parole or probation, and different entities that we get involved with as a result of working with our patient. So it could be a person has a treating relationship with that individual. So in the case of a health home, there might be different treating circumstances, whether it's a substance use provider as well as the dentist, if we make a referral to a dentist, or if we make referral to a housing organization. So those are entities that have a non-treating provider relationship. The name of the program making the disclosure, so where you're coming from, the name of the individual or organization that will receive disclosure, the purpose of the disclosure, and a description of how much and what kind of information to be disclosed. And it's important to also exercise the patient's right to revoke the consent in writing and exceptions to the right to revoke, or if the exceptions are included in the program notice, a reference to the notice. Also, the program's ability to condition treatment, payment, enrollment, eligibility of benefits on the patients agreeing to sign the consent by either stating that the program may not condition these services on the patient signing the consent, or consequences for the patient refusing to sign the consent. And oftentimes we get that with criminal justice releases where the patient doesn't want to sign a release of information from the parole officer. This could, in fact, be problematic to the treatment, the program that's providing care. So we have to decide, and talking with the patient in a person-centered way, the importance of having certain consents to help the individual gain recovery and deal with some of those specifics around their substance use disorder. Also, the date of the event or condition upon which the consent expires, if not previously revoked. And if it's revoked, it's really important to make sure it's clear on the consent, so that way there's no mistake if other personnel or counselors within the program end up doing something when you're on vacation or away. We want to make sure that the chart is clear about who can we communicate with and who we can't. The signature of the patient or authorized person, and if it's a person who is not of 18 years old, we also need a guardian or parent, and the date on which the consent is signed. A consent that does not contain all these elements is really unacceptable, and so it's important to make sure that you take a look at your consents and ensure that they are complete. We talked a little bit before about internal communications, and 42 CFR Part 2 permits program staff to disclose information to other staff within the program or to an entity having direct administrative control of the program. Staff members who do not need to know information about particular patients should not have access or attempt to have access of the information. HIPAA also requires that the covered entity makes reasonable efforts to limit the information being shared and the minimum necessity or minimum necessary to accomplish the intended purpose. Both laws permit programs to disclose information which does not identify the patient in any way, and programs can report aggregate data about patients as long as there's no identifying information disclosed. When it comes to medical emergencies, both HIPAA and 42 CFR permit disclosures to medical personnel to the extent necessary to meet a bona fide medical emergency of a patient or any other individual. If we are sending the patient out to the emergency room on a non-urgent care, it's best to get the consent so that way we can integrate the information that is gleaned from that emergency room visit and ensure that we're doing follow-up on whatever that particular situation is. Patients' identifying information may be disclosed to medical personnel who have a need for the information about a patient for the purpose of treating a condition which poses an immediate threat to the health of any individual and that requires immediate medical intervention. So in those cases where, and we have experienced a lot of that within the ATCs, people come in to admission after using high doses of opiates, may code or go unconscious as they come into the program. So in those particular instances, we are enacting emergency care immediately without consents. And under 42 CFR Part 2, programs cannot disclose confidential information to the police or non-medical personnel, including family members. And Mark's going to spend a little bit of time on that as well, and remembering that, and sometimes as we see the police officer and, you know, we want to be able to be helpful and we also have to be mindful of confidentiality laws. So he will get into some specifics regarding the police with regard to Title 42 issues. Best practices, a program wants to be able to notify family members in the event of a medical emergency. So in your admissions process, it's really important to ask patients in advance someone to be notified. The next of kin is important. So if the patient completes that, then we know who to contact in the event of an emergency, and that patient might not be able to be communicating to the family member that specific information. And so whenever a disclosure is made in connection with a medical emergency, the program must document in the patient record the name and the affiliation of the recipient of the information, the name of the individual making the disclosure, the date and time of the disclosure, and the nature of the emergency, as well as you will probably have an incident report as a result of that. Now I'm going to turn it over to Mark, who's going to talk about court-ordered disclosures.
All right, thanks, Maria. So, court-ordered disclosures, it's not uncommon for a provider to receive subpoenas or court orders requesting that information to be disclosed to courts relative to a patient. So, Part 2 does provide that a properly executed court order may be issued authorizing the information to be disclosed. However, certain procedures have to be followed, and these procedures have to be followed whether the court is a state or federal court. So it's not sufficient, even with a judge, to sign a simple order just ordering the information to be disclosed from a provider. There's certain steps that have to be followed, and Part 2 is quite clear about what those procedures are. And under Part 2, the subpoena, search warrant, arrest warrant, unless they follow and identify in the document that they followed the correct procedure, they're not sufficient for a program to be warranted to disclose the information. A subpoena can be used to require a program to attend or program personnel to attend a hearing to see whether the court order of the information should be issued. And so one of the issues with court orders and a program's compliance with the court order is you have to remember that Part 2 indicates that particular confidential patient information can't be disclosed pursuant to a court order or a warrant unless proper procedure is followed by the court. However, subpoenas that are issued by a court follow state law, and subpoenas that are directed at program personnel to appear before the court, those have to be complied with consistent with state or federal law, depending on the court that's issuing the subpoena. So even when you get a subpoena for information that's not legally sufficient or appropriate to disclose information, but that subpoena also requires the appearance of personnel, the program has to ensure that they don't violate the court order by not having program personnel appear as directed. But usually what happens is when the subpoena is not sufficient for the information, some communication between the program and the issuing party can usually resolve some of that. And I'll talk a little bit about that more as we go through this. As laid out in Part 2, and this remains the case under the final rule. This really wasn't changed at all. Before a court can issue an order regarding patient records, the court has to give the individual and the program holding the records an opportunity to make a presentation as to why the information shouldn't be disclosed. So often the program is served with a subpoena to appear, And that's usually done under state law through an order to show cause, where the program is the program is advised that at a particular place and time, the court will consider the matter of whether the information should be disclosed. And so that's generally served on any program that may have information about the particular subject. It should also be served on the particular subject. Generally, a program doesn't have a duty to necessarily report under an order to show cause unless they want to. The program doesn't have the obligation to go in and argue that the information shouldn't be disclosed. That generally falls to the individual. But a program has that ability, if it, for whatever the particular reasons are, to go in and attempt to resist the disclosure. So if either the individual or the program is trying to resist disclosure, the court has to listen to the parties, and unless the court finds a good cause for the release of disclosure, generally the information shouldn't be disclosed. And so good cause, as it's defined, is determined that the public interest and the need of the disclosure outweigh any adverse effect that disclosure will have on the patient, the doctor-patient relationship of the program to the client, and the effectiveness of the treatment program services. So other than in cases of child neglect or abuse, the court will really, or should really, scrutinize the purpose for the disclosure. If the client is involved in the legal proceeding, and the client themselves has not put forth anything that's in the record, in the patient's record, or in their past that's been recorded, then generally the court should defer disclosure of that record. There's also prohibitions in Part 2 directly about releasing records to law enforcement agencies or releasing records for the purpose of prosecuting a particular individual. These are somewhat tricky situations, especially in relation to police coming into the. Is this a good time, Maria, to talk about that? This situation of police coming into
exactly.
Okay,
exactly.
So the service or the attempt of service of a warrant or arrest warrant or a subpoena on a program is pretty tricky for a program to address sometimes, because it again brings in the requirements of Part 2 that indicate that a program shouldn't be making disclosures unless that disclosure is consistent with the exceptions under Part 2. And you've got generally state, but sometimes federal personnel that are lawfully attempting to effectuate an arrest warrant or a search warrant. And so you've got this conflict of overlapping laws, and the provider is standing there trying to figure out how to address the situation without violating either one of them. And so what we've found over time is if law enforcement appear at the facility, they are looking for a particular individual that they believe is a client of the program. The program can't disclose whether that individual is or is not a client of the program, but certainly the facility will probably discern whether they are in the facility. If the police want to effectuate an arrest warrant, what the program can generally do successfully is just indicate to the police that under Part 2 they can't disclose whether the individual is in the facility or not. But they just ask them to hold fast for a few minutes. And generally, most of the time, and chime in, Maria, if this is not your experience, most of the time the program staff can go find the individual that the police are looking for, talk to that individual, and hopefully, and I think most of the time.
I would say most of the time we've had one or two situations where someone did not agree to let them know that they were there.
Right. And so if that, in that case, that makes it somewhat easy. The program just introduces the law enforcement staff to the client that they're seeking, and the law enforcement staff just proceed to do what they came to do. In situations where the individual is not willing to cooperate, then the provider is put into a bit of a bind that they have to be careful how they address this, because on one hand they want to try to protect the other clients being identified by the police if the police decide to proceed through the facility to locate the individual they're seeking. The provider also has to be aware that they don't want to put themselves in a situation where the client now is aware that the police are seeking to arrest this individual, and because of the delay in time, the client attempts to escape from the prison, or escape from the facility, thereby setting up a scenario where the police may suggest that the program was actually facilitating this individual's escape from their custody. So the program, when a client doesn't want to cooperate, the program has to make clear to that individual that the program's not a sanctuary. The program does not have any illegal ability to prevent the arrest that the law enforcement wants to effectuate on them. And so either the person cooperates, and if they can continue not to cooperate, then the program has to sort of shift gears and make sure that the rest of the clients are moved out of a location so that their identity and confidentiality are preserved, and then allow the law enforcement to proceed to come in and take custody of that particular individual.
And that's really a therapeutic intervention. You know, that's where we have to utilize specific skills to help the individual see that recovery is still possible, and that by being honest and coming forth, those are good things that get a foundation of recovery going and starting, because holding back and keeping secrets are things that help or assist the person in not getting better.
Right.
So it is an opportunity for therapeutic intervention as well. I just wanted to say that.
No, I think that's important to stress, especially in that environment. In the situations where subpoenas are served improperly, or I should say they're served with under improper format, that they don't allow an opportunity for the program or the particular subject to appear before the court and argue that their records shouldn't be disclosed. Generally, the mechanism that we employ is just to reach out to the requesting individual or office and indicate that the program, because of Part 2, cannot comply with the subpoena the way it's addressed, and then advise them as to Part 2, advise them as to the requirements of Part 2, and they're very clear in Part 2 that any law firm or any DA's office or prosecutor's office can go through and structure a subpoena so that it's properly formatted, and then serve that on the program to get the records that they want. Generally, we can facilitate a very high exchange of records because the program is free to disclose them as long as the court order or the subpoena have been properly prepared. So. Would you like me to do this one as well?
Yes.
Yeah, okay. So patient crimes on program premises, it does happen, unfortunately. So there are times when Part 2 allows for a limited amount of information, which does in fact identify an individual as a client of the program to be disclosed without a consent. And one of those is crimes committed on the program premises or against program personnel. And so if something like that happens, a crime on the program premises, or threats or something even more drastic against program personnel, a program can reach out to the police. They can identify the individual. They can identify them as a client. They can give the last known contact information for that individual. If for some reason the individual is no longer in the program, physically in the program. And those disclosures are permissible. Now, that's to be distinguished against the situation where a client during counseling discloses crimes that they've committed. Those are not covered by this particular exception. These are only crimes that are committed on the program, while in the program, or against program staff.
Okay. Thank you.
So, of course, in any situation, the program making a disclosure under this particular exception wants to be fairly confident that they are actually disclosing the correct individual as the suspect of whatever the offense might be. So it's just there's a bit of reasonableness that has to go into deciding whether they should contact the police. But if it's the individual suspected, they can provide the information. You don't turn over, program can't turn over the entire program file or a treatment file to the police. They're just the minimum information that I discussed. And when if an individual staff member or something is involved, they have to keep their testimony simply to the events of the incident, and not, again, the whole entire program treatment file isn't disclosed at that time. But it's definitely, as pointed out, it's something that requires a little bit of consideration. So the program administration should definitely be contacted and discuss whether this outreach to the law enforcement is warranted or not.
Thank you. Thank you very much. I think here we're just taking a look at qualified service agreements again, which we kind of talked about before, earlier in this presentation. So both HIPAA and CFR 42 Part 2 provide mechanisms that allow programs to disclose information without the patient's consent to an outside organization that provides services to the programs. So these are some examples, as we talked about before: the laboratory, the Justice Center, pharmacy services. If your physician has an on-call status with an on-call company receiving information, these are all different entities that fall under the qualified service agreement.
Maria, if I could just...
Absolutely.
So one of the things about a qualified service organization is, of course, by its nature, it allows a program to disclose information without the patient's consent. But that shouldn't be without the patient's knowledge, per se. QSOAs are effective, they're legal, their bod use is totally acceptable. But in these days of electronic health exchange and everything, information exchange, they do run the risk of information being disclosed appropriately under a QSOA without the client's knowledge. And that can lead to potential issues down the road when the client had no idea that their information was disclosed to certain parties. And so a program has to be very careful about using a QSOA, and if they are going to use them, which is appropriate, they should ensure that the client is aware that that information has been disclosed pursuant to QSOA.
So in this particular slide, you see that it's important with a QSOA that the person who is getting the information is also bound by 42 CFR Part 2 and HIPAA. Also, to resist in judicial proceedings, if necessary, any efforts to obtain access to information pertaining to patients except as permitted by 42 CFR Part 2. And last but not least, in developing your QSA, it's really important to consult your, if you have a particular counsel's office within your agency, assuring that the language in the QSOA is not something that would be problematic and against the regulations. So now we're going to spend a little bit of time just having you know that besides the federal laws with HIPAA and 42 CFR Part 2, we have the state confidentiality law. So New York State has a confidentiality law as well. And it's Mental Hygiene Law 22.05, patient records. All records of identity, diagnosis, prognosis, or treatment in connection with a person's receipt of chemical dependency services shall be confidential, shall be released only in accordance with the applicable provisions of public law, any other state law, federal law, and duly executed court orders. So not only do we have confidentiality on the federal level, we have it on the state level as well. Our patient rights, OASAS Part 815, has some provisions around confidentiality. A provider shall comply with federal confidentiality regulations. So we're asking programs to comply with 42 CFR. We're asking them to comply with HIPAA and the public health law. And at the time of admission, the provider should inform each patient that federal and state laws protect their confidentiality of all records, including their identity, diagnosis, prognosis, and treatment in connection with a person's attendance, participation, or receipt of chemical dependency services. So as I've told you before, it's really important to talk about the fact, though, you still have internal communications and that you work as a multidisciplinary team. And such information shall be released only in accordance with applicable provisions of federal and state law. And those are stated in Part 815. Providers should adhere to 42 CFR Part 2 as well under this. Providers shall have a policy that ensures an end date to all released confidential information. So not only is it stated in Title 42, it's stated within Part 18 about the end dates. And copies of records should be given to patients or former patients upon request, in accordance with applicable law, regulations, and the program's procedures. And what we're asking for is that information is relayed to the other entity within 15 calendar days. So there is a time limit with regard to how long it takes us to provide that information to wherever that patient would like the information to go. Justice Center also, as I've talked about throughout this presentation, in their Part 836, identifies a breach in confidentiality as a significant incident. So any violation of a client's rights to confidentiality pursuant to 42 CFR Part 2 or HIPAA is considered a confidentiality breach and significant incident under the Justice Center. Also for CASACs and certified prevention and gambling specialists, we need to embrace as a primary obligation the duty of protecting the privacy of patients and must not disclose confidential information acquired in teaching, practice, research, or investigation, and maintain confidentiality of records they control. And that even means sometimes information that you have on your desk. While it is your office, you have to be cognizant of patient names and information that you might have a particular note of something about that person. So what I gave here are some potential lists of violations of confidentiality, and these are some that we were able to see through incidents within OASAS. First one being, and most problematic I would say, is incorrect email addresses. And especially when our email addresses have same last names, such as Smith or Jones. Oftentimes there are numerous individuals with that last name. And so when the computer is auto populating names, they might pick the name that doesn't mean who you would like it to go to, and therefore then information may go to an incorrect entity. So what we require in the ATCs is a little sign on the computer to check before you hit send, because that is probably the most prevalent violation that we experience in the ATCs. Giving discharge medications to the wrong patient. So as we're preparing for discharge and the patient is always excited about leaving and wants to get out as soon as possible, and we have a lot of activities also going on at the same time. Sometimes admissions are happening at the same time as discharges, so we need to be cognizant of medications that we're preparing for that next level of care. Leaving patient rosters out in view of other patients. As we're documenting the presence of patients throughout our day, and we need to make sure that that information isn't just left in a group room or left in view of the patients. And also not assigning that roster to patients if it contains last names and other information about that individual. Sending clinical information to the next level of care without checking to ensure that the patient has signed a consent. Sometimes that happens with the primary counselor, and sometimes that happens to someone who is filling in for the primary counselor and trying to get information and work out. We have to double check to make sure that the person has made consent. Discussing patient information in ear distance of other patients, and talking in the hallways, talking on the elevator. Oftentimes it's helpful to have a confidentiality posting within those areas to keep reminding staff that talking about specific patient information in earshot of others is a breach of confidentiality. Also identifying patients by their prescribed medications. Everyone who's here for Suboxone, come in this line over here. I've heard our programs do that, so now we're separating our clients based on information about the medications that they take. Same thing with HIV medications. So we want to be very cognizant of that information also provides patient-protected information. Leaving patient information on the copy or fax machine, again, in view of others, and especially if someone is coming to fix the machine and you left all the information that got stuck, let's say, there on the machine. So it's really important to keep all your information out of those general areas where many people can be. And last but not least, the dual relationships, which we've discussed in other ethical presentations. When we know somebody from our community, and many times that happens in rural areas, but it can happen in other areas as well, and knowing that patient outside of the treatment setting, you should not be providing information that the patient hasn't disclosed themselves within the record, or what you know about them as a child or their family members. So knowing somebody and understanding that dual relationship is really important to disclose up front. So if you know somebody from your personal life and now that individual is coming into care, you should inform supervisor and decide how you're going to proceed with your participation in the multidisciplinary team setting. There is procedure when a breach of confidentiality is discovered, and you should have a policy and procedure, a confidentiality policy and procedure. One, you need to notify the Justice Center of the significant incident, complete the incident report and submit it to the Justice Center or your program. Inform the patient that a breach did occur and ask them if there's anything he or she would request from the program. So it's really important to get back to the individual to let them know that this happened. This is good practice. It's something that does happen. And oftentimes you may find that the corrective action is something that would make the individual feel more comfortable after something like that has occurred. Many programs have a privacy violation form and a privacy officer. So they are those individuals who are keeping track of the confidentiality breaches. And it's important to discuss and document corrective actions to avoid further breaches. We want to be able to maintain a record of confidentiality breaches as part of your risk management program to determine any systemic corrective action. And so what we like to do is bring those the information about a breach of information to our committee where we review incident reports and decide how are we going to avoid this kind of thing from happening again. Staff and providers must be aware that routine office practices, including telephone contact and verbal discussions and computer use, inherently carry a risk of patient confidentiality breaches. So it's important to have your confidentiality training yearly at your program, and you should have it documented and maintained in personnel files. Annual confidentiality agreements should be signed off by all staff, reminding them of the specifics around confidentiality and the federal laws. Email addresses should be double-checked for correctness before sending out. And in some places, we have actually turned off that auto-populate because that is something you can maneuver within your computer so that a person has to type in the name each time they're sending information. Any internal email communication should never use the full name of the patient. So if you only have the first name, then things will, at least that's minimally providing the information that you need and avoids a confidentiality breach. Conversations about patient care should not be audible to others and visitors in the waiting area. And personnel should never be advised to discuss patients outside the office. We should bring people in an office and have that discussion versus having it in the hallway. Also, access a flow of patients through the office determine how to best maintain privacy of personal health information. So understanding, as I talked about before, where your admissions department is and how you're communicating. Oftentimes when offices are close to one another, people tend to shout versus going into the office and requesting something. So take a look at how your actual office practice is operating. Computer screens should not be visible to patients or visitors. There are screens you can use to put on your monitor so that people can't see what is on the computer. Computer in exam rooms should not be left on or active when staff or providers are not present. Any electronic device used for the transmission of personal health information must be encrypted and have regular updates installed. And if your practice leaves messages on patients' answering machines, it must be contained in your notice of privacy practices. And so it's important to ask the individual, if we do want to call you, is it okay to leave a message? If not, then you're going to have to find a way to contact that individual without giving up the fact that you are a substance use treatment program. Patients must be offered an option of opting out and in terms of messages, and business associate agreements and QSOAs must be obtained and maintained on all vendors who have access to personal health information. And what we have here is our references, and I can't say enough about the Legal Action Center. The Legal Action Center provides a lot of guidance and has provided guidance in terminology that's understandable to all. But information is listed here, And you can feel free to call Mark or myself. We have emails and identifying your questions, and hopefully we can get you the answers that you're looking for. So on behalf of OASAS, I want to thank you for your participation today. I want to thank Mark for being with me and helping me sort through those difficulties.
Oh, you did great. Thank you. Thanks.
Thank you very much.
Thank you.
Well, Maria and Mark, I would like to thank you for your time and also for providing a complicated subject and attempting to help make it a little bit easier to understand. So again, thank you for that. Folks, Learning Thursday's evaluation, very simple. You can read through it. We really appreciate your feedback, as it's one way for us to gauge if we're meeting the educational and or professional needs of the field and of you as an individual. So if you would do me a favor and take a moment to complete the survey, I would most appreciate it. Thank you. And as always, I want to thank staff at Media Services, because they do a phenomenal job behind the scenes of keeping track of us, keeping us on point, and helping to provide you with a very professional product. So folks, thank you. Thank all of you for joining us, and I will see you in December. Bye now.